Welcome back to the class video for Module 6, in which we're looking at John Dickinson's Letters from a Pennsylvania Farmer. In the first part of class, we looked at Dickinson's historical context in 1767, both the long history of the British trade empire and the rules that governed it, and then the attempts by Parliament to change the fundamental financial structure of the empire in the 1760s, which brings about colonial protest. In the second part of Module 6, we looked at the first two of the letters, in which Dickinson lays out a kind of conceptual blueprint of the constitutional structure of the empire, and then we see the fundamental conceptual problems then he faces in trying to define his opposition to the Townshend duties. Having conceded Parliament's sovereignty over imperial trade, that is, to govern that space between the British Isles and the colonies themselves, having conceded the sovereign authority over the relationships between the parts of the empire, on what basis then can Dickinson claim that the Townshend duties are tyrannical or unconstitutional? This little, if you will, Rubik's Cube or Sudoku puzzle that Dickinson has to align then is what compels him and other colonial writers to emphasize that these acts of Parliament are in fact taxes upon the colonists, and to rely upon that ancient British right, at least since 1688, that only the people's representatives chosen through either Parliament in Great Britain, or Dickinson would have it the colonial legislatures for the colonists, have the constitutional authority to impose taxes. Now, whether it's a tax or not, or a tax of the sort that Dickinson would want us to believe, is a open question of debate. But it's that rhetorical move which leads the colonists to emphasize representation and taxation as the core constitutional issues. So we have the basic conceptual problem. Now the problem with Dickinson's letters is we're not building towards any particular solution here. He's not going to unsolve this Gordian or untie this Gordian knot. He is going to entertain now here in the next two letters two additional kinds of objections to his arguments or counter arguments to his own. He's not going to give us particularly satisfactory answers on either, and then he's going to turn in the last letter and make a broader claim about the colonists' union and common identity as colonists, and it's a very different kind of argument. So we're not going to find here some great solution to the problem that he has identified, but we are going to see a change in the nature of the argument, which is going to be our segue to reading Tom Paine in Module 7. So let's turn now back to the text and look at Letter 4 and the arguments that the colonists had made in response to the Stamp Act just 2 years prior to the Townshend duties. Now, one big obvious problem that any colonial writer in 1767 attempting to convince their fellow colonists that Parliament is acting tyrannically and they have to rise up in resistance, one big obvious problem that any such writer faces is that Parliament compromised and conceded to colonial objections about the Stamp Act. Right? In 1765, Parliament said, we're going to impose this tax on you. The colonists rose up, they raised holy hell in resistance against imperial authority, and rather than shoving the Stamp Act down the colonists' throat, Parliament retracted it. Now, they passed an act that said we could impose it if we want to, but in fact they repealed the law. And sort of oversimplify the debate, Parliament has essentially conceded and said, okay, you don't want an internal tax, then we will impose a tax over here in Great Britain that is external to you. Surely no one can object to the power of Parliament to impose a tax on residents of London and Glasgow and Edinburgh and Birmingham and the other cities of the British Isles. Surely we are the legislature that is sovereign over this territory. So in recognition of your opposition to our first attempt, we will take this second attempt that surely no one can object to. Now that's a gross oversimplification of the back and forth, but think of any kind of neutral third-party observer. Imagine that you're neither a resident of Great Britain nor a resident in the colonies. You're French or Swiss or Belgian or something, and you're watching this constitutional struggle between the British Parliament and its colonies. Any neutral third-party observer would certainly say, well, geez, Parliament has made a major concession here. They have conceded your point of internal sovereignty, and why should they not be able to tax residents of their own realm? That is the problem that Dickinson is going to try to address here in Letter 4. He begins Letter 4 in the right-hand column, top of page 7. An objection I hear has been made against my second letter, which I would willingly clear up before I proceed. There is, say these objectors, a material difference between the Stamp Act and the late Act for laying a duty on paper, etc., that justifies the conduct of those who oppose the former, yet are willing to submit to the latter. The duties imposed by the Stamp Act were internal taxes, but the present are external, and therefore the Parliament may have a right to impose them. And so Dickinson must radically expand the arguments that the colonists had been making just 2 years prior. He follows, "To this I answer, with a total denial of the power of Parliament to lay upon these colonies any tax whatever. This point, being so important to this and to succeeding generations, I wish to be clearly understood. To the word tax, I annex that meaning which the Constitution and history of England require to be annexed to it. That is, that it is an imposition on the subject for the sole purpose of levying money." In evoking the Constitution and history of England, Dickinson is calling upon the core principles of the 17th century struggle between Parliament and King, triumphed in 1688 with the Glorious Revolution. The core constitutional struggle around the right of taxation is best summarized when Dickinson cites this kind of axiom of the common law here in the highlighted passage at the bottom of the right-hand column. All these sums were levied upon the people by virtue of their voluntary gift. This is the core kind of parliamentary position all the way through the 17th century as they're arguing with the king over who has the right to impose taxes. Parliament insists that all taxes are in fact the voluntary gift of the people, because the king does not own their property. The people own their own property. Therefore, when they are taxed, it can only be through their own representatives in Parliament, who are bestowing upon the king this voluntary gift of their own property, because they're virtue-loving subjects and they want the realm to succeed, and they love the king and they think the king's a great ruler, so they voluntarily give over their property to support the king, and they do so through the institution of Parliament. In invoking that phrase, levied upon the people by virtue of their voluntary gift, Dickinson is exactly sticking his thumb in the eye of those members of Parliament who claim that Britain is a great constitutional order because of the principles established in 1688. He is telling them, if you really believe that, then you would recognize that this is not our voluntary gift. Now, as we already mentioned in the last segment, there are two ways of interpreting what was established in 1688. One is that the people, through their voluntary gift, do so through whatever their local legislature is, right? That's one way. That is, that principle is replicated at a lower tier for the colonies. Or another way of interpreting 1688 is You're exactly right. Parliament is the institution for all British subjects. That is, Parliament by 1688 was established as the apex of the pyramid of sovereign authority, as Dickinson has already conceded their power to regulate trade among the parts of the empire, the relationships among the parts of the empire. Trying to sort those acts of Parliament legitimate because they govern trade, right? Even though they are not the voluntary gift of the colonists, they are nevertheless legitimate because Parliament has sovereign authority over trade. And distinguishing those from these terrible tyrannical acts of Parliament, which are taxes because they are not the voluntary gift of the colonists, leads Dickinson into a kind of definitional morass. The whole set of categories that he set out at the beginning start to dissolve on him. First, he's going to cite this, the declaration of what's known as the Albany Congress at New York. Now, this is sort of irrelevant because he's essentially citing one important document of colonial protest that does not mention the distinction between internal and external taxes, but he is ignoring all those many other documents of colonial protest that do focus centrally on the distinction between internal and external taxes. So he does a little rhetorical feint here, but we really see the trouble that his conceptual categories are getting into on the right-hand column of page 8 in these last couple of paragraphs. He writes, and starting at the center of the right-hand column of 8, "This language is clear and important. A tax means an imposition to raise money. Such persons, therefore, as speak of internal and external taxes, I pray may pardon me if I object to that expression as applied to the privileges and interests of these colonies. There may be internal and external impositions, founded on different principles and having different tendencies. Every tax being an imposition, though every imposition is not a tax. But all taxes are founded on the same principles and have the same tendencies. External impositions for the regulation of our trade do not grant to His Majesty the property of the colonies. They only prevent the colonies acquiring property in things not necessary in a manner judged to be injurious to the welfare of the whole empire. But the last statute respecting us grants to His Majesty the property of the colonies by laying duties upon the manufactures of Great Britain, which they must take, and which she settled them on purpose that they should take." Now you are to be forgiven if you're having an enormously difficult time following Dickinson's reasoning here, right? I challenge you to present a Venn diagram that accurately represents these set of definitional categories. We are to believe that if Parliament collects money from a merchant in Great Britain for the purpose of regulating the trade of the empire, it is of no constitutional consequence that the merchant will turn around and raise his prices to the colonists. But if Parliament collects exactly the same amount of money from exactly that same merchant for the purpose of getting money out of the colonists, then that makes the act tyrannical. One is an imposition, and it's okay. I mean, it's not great. The colonists don't like it, but they have no constitutional objection to it. The other is a tax, and this is a violation of the most sacred principles of the British Constitution going back centuries. If nothing else, these are exceedingly fine and detailed categories on which to base claims of revolutionary right. You're having to make extremely meticulous distinctions, and ultimately, as we'll see in letter 6, that's really founded upon claims over the motives of the person acting. And we'll see that now. Let's turn to letter 6. In letter 6, Dickinson deals with another very obvious objection to the logic of his arguments around the Townshend duties. The core function of the acts of trade, that British trade network system over more than a century, was that Britain collected taxes on the property of the colonists when they shipped their enumerated commodities to Great Britain. That was the core function of the system. If you grew tobacco or rice or sugar, you were legally obligated to send it to Great Britain where they taxed it. That is very clearly taxing the colonists' property. Dickinson does not have a particularly good answer to this objection either. He begins letter 6. It may perhaps be objected against the arguments that have been offered to the public concerning the legal power of Parliament, that it has always exercised the power of improving duties for the purposes of raising a revenue on the productions of these colonies carried to Great Britain, which may be called a tax on them. To this objection I answer that this is no violation of the rights of the colonies, it being implied in the relation between them and Great Britain that they should not carry such commodities to other nations as should enable them to interfere with the mother countries. Notice how vague that threshold criteria is described as it being implied in the relation between them. And just below the highlighted passage, it is only a consequence of her parental right. So Dickinson finds himself in a place saying, it is perfectly constitutional for Parliament to order a South Carolina rice plantation owner to ship his rice to Great Britain and to pay a tax on it when it arrives in a British port, but it is tyranny for Parliament to turn around and to impose a tax on a glass or paint or iron manufacturing shop in London before they ship their goods to the colonies. In both this example and the one at the end of letter 4, trying to distinguish between a tax and an imposition, we can see how difficult a time Dickinson is having trying to point to the thing that Parliament is doing that is such a gross violation of the principles of the British Constitution. And it's rooted in a problem of interpretation, this methodological process of determining constitutionality by the legislature's intent. In the highlighted passage at the bottom of the right-hand column of 9, it may be perhaps further objected that it being granted the statutes made for regulating trade are binding upon us, it will be difficult for any persons but the makers of laws to determine which of them are made for regulating trade and which for raising a revenue, and that from hence may arise confusion. This is the interpretive problem we've been tracking from the beginning. The exact same exercise of governmental power may be tyrannical and unconstitutional if done for one purpose, but perfectly legitimate and binding if done for a different purpose. Well, how are we to know the purpose of the legislature, especially because the legislature could claim to have any purpose? So if the only thing that you need to do to make an act of power constitutional is say, I'm doing this for the good of the people, you would never be able to declare any act of government unconstitutional. It is an intrinsically kind of ambiguous and ambivalent method of determining whether constitutional authority, whether governmental authority is behaving constitutionally. Now, fortunately, Dickinson doesn't have that problem with the two acts that he's concerned about, right? The Stamp Act and the Townshend duties, because as he has already told us, they declared in their preamble that they're doing this for the purpose of raising a revenue. So he thinks it's a slam dunk case in this particular instance, but that he wants to deal with the underlying conceptual problem or interpretive challenge here. And so he says on the left-hand column of 10 at the top, however, supposing the design of Parliament had not been expressed, the objection seems to me of no weight with regard to the influence which those who may make it might expect it ought to have on the conduct of these colonies. It is true that impositions for raising a revenue may be hereafter called regulations of trade, but names will not change the nature of things. Suppose that Parliament passed exactly the same law as the Townshend Duties, or an identical law to the Stamp Act, but they simply deleted the preamble which says the reason we're passing this law is to raise a revenue for the king. Imagine they just rewrite the preamble and it says, for the purposes of regulating the trade among all the parts of the empire and keeping everybody prosperous and working hard and getting the things they need to make their economies work. That's why we're passing this law. And then it enacts exactly the same governmental power, exactly the same outcome of people having their property deprived from them through the form of, whether you want to call it tax or an imposition or whatever goofy name you want to come up with it, it's the exact same exercise of power. Dickinson's answer is, well, they may hereafter be called regulations of trade, but names will not change the nature of things. Notice how that contradicts what he just said, the core of his argument. The core of his argument is it's exactly the purpose of things that determines constitutionality. But here he says names will not change the nature of things. And he gives us a great little analogy or example here at the bottom of the left-hand column. He writes in the highlighted passage, suppose a prince, for some unjust purposes, should from time to time advance so many needy profligate wretches to that rank that all independence of the House of Lords should be destroyed. There would then be a manifest violation of the Constitution under the appearance of using legal prerogative. And he gives a comparable example for the House of Commons at the top of the right-hand column. The House of Commons claims the privilege of forming all money bills and will not suffer either of the other branches of the legislature to add to or alter them, contending that their power simply extends to an acceptance or rejection of them. Skip down. Suppose a future House, influenced by some displaced, discontented demagogues, in a time of danger, should tack to a money bill something so injurious to the king and peers that they would not assent to it, yet the Commons should obstinately insist on it. The whole kingdom would be exposed to ruin by them under the appearance of maintaining valuable privileges. In these cases, it might be difficult for a while to determine whether the king intended to exercise his prerogative in a constitutional manner or not, and whether the Commons insisted on their demand factiously or for the public good. But surely the conduct of the Crown or of the House would in time sufficiently explain itself. So think now of Locke's final paragraphs and the way he turns himself into a pretzel trying to decide who shall judge whether the king acts contrary to their trust. And he goes back and forth between the individual and the collective. Watch Dickinson's or read Dickinson's final paragraph here on 10. Ought not the people therefore to watch, to observe facts, to search into causes, to investigate designs, and have they not a right of judging from the evidence before them on no slighter points than their liberty and happiness? So Dickinson claims for the people a right to judge, but how can the people know or prove what the intent or the motive or the purpose behind the exercise of governmental authority is? This is an exceedingly ambiguous, gray, indeterminate standard to declare a revolutionary right. The danger from a Lockean perspective now, if you recall John Locke, is that if you set too low a standard for the right of revolution, you are giving a license to anarchy and confusion, right? If you can, on any slight cause, decide that you don't like a law, then everyone has a license to disregard whatever laws they disagree with. You can feel Dickinson's confidence fading, right? His conceptual confusion as he's trying to sort out clear categories. Aha! That's the moment we know they acted unconstitutionally. Now, he thinks he has a kind of out here, because Parliament wrote in the preamble, this is for the sake of revenue. But his difficulty in answering this challenge, well, what if they didn't write that in the preamble? Imagine a different case where the president has the right to appoint judges of the Supreme Court, but he appoints judges who want to destroy the Supreme Court, right? The president is acting, doing things that are clearly bestowed upon him by the Constitution. There can be no objection that he has the right to exercise this power, but can he do it for that purpose? And this gets to the heart of the conceptual difficulty of Locke's rationale for revolution. It's why he spent those last paragraphs unresolved in his mind who he could bestow the power of declaring revolution upon. He wanted to give it to every individual, but he thought you would abuse that authority if he let you decide for yourself. And so you can see the same kind of corrosive, internally unstable or imploding logic of the theory of democratic revolution. Now, we saw two ways of thinking about the right of revolution, one Lockean and one Rousseauian. Rousseau relies less upon specific violations of the forms and rules of law, and he relies more upon the identity of the collective, of the general will, right? The cultural identity of the people, and arguments that the exercise of power is inconsistent with what it is to be a Briton. A much vaguer and radical kind of standard for revolution, but one which relies much more strongly on a collective cultural identity. And indeed, that's where we're going to see Dickinson turn in letter 12 to a different kind of argument, one that invokes the colonists' common cultural identity or union. So let's look at, finally, letter 12. Now we're skipping over several letters in between, but when we arrive at Dickinson's final letter 12, we can't help but notice the change in tone. All the way through, Dickinson is meticulous in pointing out and citing specific acts of Parliament and making arguments based on the specific text and the legal definitions of different words that Parliament uses. Indeed, Dickinson's place, especially in the early part of the literature of the Revolution, is as a kind of expert lawyer. His place in the canon, these letters' place in the canon, is through their capacity to draw this kind of blueprint, how the colonists envision the legal structure of the empire. And so we can't but help notice the change here in letter 12 to this broad rhetorical claims, this kind of poetry of freedom that we see in the final letter. And that makes a certain kind of sense within context. That is to say, after 11 letters of citing statutes of Parliament and making lawyers' arguments, you can imagine this as kind of the grand finale, right? And so he's going to give himself some rhetorical license to use emotional phrases. But for our purposes, it's also important to understand that it is his frustration and inability to satisfy Lockean terms of tyranny, that is, to provide a convincing lawyer's case for how Parliament has changed the forms and rules of government. It's his inability to succeed in that argument for revolution that brings him to an alternative way of thinking about revolution that we've seen, the Rousseauian model. And of course, Rousseau's model of revolution depends not so much on kind of black letter law, parking ticket citations, kinds of things that you can identify that government has violated, but instead depends on our cultural identity. The agreement by which a people became a people before they chose government. And it's simply enough for the people to declare, we no longer recognize ourselves in this government. The government has alienated itself from us, from no particular reason than its own natural inclination to gather power. So there's a much stronger emphasis on cultural identity in the Rousseauian approach, and that's exactly what we see Dickinson leaning on here in his final letter. He begins letter 12. Some states have lost their liberty by particular accidents, but this calamity is generally owing to the decay of virtue. A people is traveling fast to destruction when individuals consider their interests as distinct from those of the public. So he's calling upon this classic antagonism between self-interest and the common good. When individuals consider their interests as distinct from those of the public. What happens when people do that? That is the decay of virtue. What happens when virtue decays? A people loses its liberty. So it's the common good. It is the collective identity which is the source of virtue to which we can return to claim political legitimacy. And the shorthand or the kind of euphemism that emerges in American political discourse to embody this cultural identity is the word union. So when the revolutionary writers and constitutional writers invoke this word union, what they mean, the American Union, what they mean is that identity as Americans, as distinct from being Britons. At the top of the right-hand column on 11, the highlighted passage, our vigilance and our union are success and safety. Our negligence and our division are distress and death. They are worse. They are shame and slavery. Now, there is a great problem with this assertion of a common American identity. Why would residents of Connecticut, Massachusetts, Pennsylvania, New Jersey, Virginia, South Carolina, why would they think of themselves as belonging to a common culture? Their primary connection first is to their home colony, so Virginians would first and foremost think of themselves as Virginians, but surely their second identity would be, I am a Briton. I am a member of the British Empire and seeking the protections or claiming the protections of the British Constitution. I am British. What is this thing American? Where can an American identity come from? That is the central focus of Tom Paine's writing that we're going to look at in the next module. But I want you to see here how it's a kind of safety valve, this cultural identity, for the frustrations of trying to meet Lockean standards for revolution. Now, what can form the foundation of an American identity? There are no long-lasting traditions or common culture. To the extent they have common cultural practices, it's because they're all British. What's the unique experience of the colonists that can form a unique American identity, an agreement by which a people could become a people? Well, it may be this common experience of carving their communities out of the wilderness, this unique experience of the state of nature, that is, the way in which they came into the ownership of their property. Look in the next highlighted passage on the right-hand column of 11. Let these truths be indelibly pressed on our minds, that we cannot be happy without being free, that we cannot be free without being secure in our property, that we cannot be secure in our property if, without our consent, others may, as by right, take it away, that taxes imposed on us by Parliament do thus take it away. Dickinson turns to the kind of classic themes of the social contract model, right? The classic themes of Locke's approach are origins in the state of nature and our development of our own individual property claims, which would make very little sense if you lived in Birmingham or Lincolnshire or London or Glasgow, or if you lived in the British Isles. That cultural narrative of carving your property directly from nature, having a natural right to being secure in your property, would just make no sense, or would be much less resonant with you. In the colonies, where they've all had this experience of carving their farms out of the frontier, this narrative of our origins, that what binds us together is the exercise of our property rights, becomes the foundation of this American Union, this cultural identity through which Americans can recognize each other primarily and British only secondarily. Now, again, Dickinson is doing this in a kind of minor way at the end of his piece, but we're going to see that this is a central theme in the story that Paine is going to tell us in Common Sense about why we should all hang together. It's because of our common experience in nature. We can get a sense of how important this is to Dickinson here, not so much through how extensively he sort of dwells on our origins in nature, but through his description of its antithesis, slavery. We find on the bottom of 12, what would be the condition if we were to permit Parliament to take our property from us? We would be like slaves at the bottom of the left-hand column of 12. Horses and oxen are content with that portion of the fruits of their work which their owners assign them in order to keep them strong enough to raise successive crops. But even these beasts will not submit to draw for their masters until they are subdued by whips and goads. Let us take care of our rights, and we therein take care of our prosperity. Slavery is ever preceded by sleep. This is one of the most common tropes of revolutionary rhetoric. If the colonists submit to parliamentary authority, it will be the equivalent of becoming slaves. Now, there's something particularly obnoxious about slave owners, though Dickinson himself, to my knowledge, is not a direct slave owner. Certainly other writers who make this argument are, right? To imagine the condition that they're holding their own slaves, and then to turn around and make the argument, if I have to pay this tax to the British Parliament, I will be in the same condition that I treat this person who works in my tobacco fields. So there is something patently preposterous, just as there is something patently preposterous about Thomas Jefferson, of all people, writing, "All men are created equal, endowed by their Creator with certain inalienable rights." At the same time, no metaphor is more powerful for creating a common cultural identity. If there is something that uniquely defines the colonies as opposed to Great Britain, it is the degree to which they are dependent upon slavery for their economic productivity. Whether you live in Pennsylvania, Philadelphia, or Boston, your prosperity is dependent on doing trade with slave owners who are producing those cash crops. Slavery is a universal in the colonial experience and radically distinct from living in the imperial center. One of the ways you know that you're living in a colony and not in the center of the empire is there are slaves around. And so you see how powerful a metaphor it is for creating a common cultural identity. Why are we a people as colonists? Why should we think of ourselves as having the sovereign authority to reject the governmental power being exercised over us? Because we all respond in the same way to the metaphor. If we submit to this tax, it'll be like being a slave. Here we can see how just totally out of character this is compared to Dickinson's earlier letters, which are so precise, meticulous, lawyerly, legalistic, and parsing apart the language of different statutes. Here he's left to the hyperbole of claiming that someone subjected to a tax passed by Parliament would be a slave. But it's that cultural identity that he concludes on all the way through the final pages and in this great final passage on 13. For my part, I am resolved to contend for the liberty delivered down to me by my ancestors. But whether I shall do it effectually or not depends on you, my countrymen. How little soever one is able to write, yet when the liberty of one's country are threatened, it is still more difficult to be silent. What a wonderful bumper sticker, right? That's the kind of slogan of the revolution that gets quoted in history textbooks. Whether I shall do it effectually depends on you, my countrymen. Well, what country, right? The country of Pennsylvania? The country of New York? The country of Massachusetts? When did these become country? In what sense are the fellow colonists countrymen? And in order for the revolution to proceed, in order for it to become radicalized, that cultural identity, we are Americans and you are British, we are distinct peoples, has to be fostered by the language and the rhetoric of the revolution. And that's the major focus of Module 7 and Paine's writing. So we'll turn to that now.